Good day, Crime Talk aficionados. We have a great show for you today. First, are we getting a little closer to discovering the motive in the Kentucky judge's courthouse shooting? Sarah Boone will not get her makeup and her hair done for trial. A federal judge finds California's anti-free speech law unconstitutional. Alec Murdaugh gets denied by the appellate courts, those pesky appellate waiver clauses. And there's an old saying, two people can keep a secret as long as one is dead. Let me give you an example. A woman learns next time she goes to kill her husband, turn off the dash cam. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can listen to us anytime on any of your favorite podcasting apps. And I was looking at some of those numbers last night. Guess what? We are over 2.1 million downloads on podcasting apps. Amazing, amazing, amazing. Thank you all. All right, before we get to the docket, first, go to CrimeTalkSearch.com. Sign up for that background subscription service today. You know you want to. You know there's somebody you want to check out. You need to go and do it. And let me give you a reason why you should go do it. One, if you have somebody new coming into your life, you need to check them out. Now, there could be stuff in there that you could be shocked about. There could be things in there where it's completely, totally boring, which we did on a story today. Totally boring. But guess what? It gives you all kinds of information as it relates to possible addresses, contact information, jobs, education, possible social media, right? We've had people look up their husbands, their spouses, and find that they have all these email addresses that they have. Why? Well, you need those to go to those inappropriate sites. Yes, check them out. So assets, criminal histories, bankruptcies, judgments, liens, everything you want to know about somebody coming into your life, or maybe someone you thought you knew and maybe you didn't. Go to CrimeTalkSearch.com, sign up for that background subscription today. And ladies and gentlemen, it's the best thing you're going to do today. And remember, you can do as many searches as your little heart desires, as long as you have that. And guess what? You can cancel at any time. CrimeTalkSearch.com. All right, aficionados, let's go ahead and get to the docket. And so let's open the record for October 3rd of 2024. Now, we've been following this story, and the former Letcher County Sheriff, Shawn Mickey Stines, was in court Tuesday, and it's all regarding the killing of the district court judge, Kevin Mullins. And there's now footage that's out there of the shooting, and we heard testimony about possible motives. And here is what we know so far. First, the shooting at the center of the case took place on September 19th, just before 3 p.m. Now, Stines, who surrendered at the scene, has been accused of shooting Judge Mullins in his private chambers while other courthouse workers were in the building, just literally outside in the clerk's office. Now, local residents say the two men were friends, and Stines served as the bailiff in Judge Mullins' court for several years before he was ultimately elected to be sheriff back in 2018. Now, the video clip was less than a minute long and did not include audio. In it, a man identified by the police as Sheriff Stines is shown firing multiple times at the judge behind his desk and then leaving the chambers. Now, Stines, who last week entered an initial plea of not guilty, has been charged with the murder and the death of Judge Mullins, who was shot and killed in his chambers there in Whitesburg, Kentucky. Now, the Kentucky State Police Detective Clayton Stamper testified that the full video shows Stines using his own phone to make multiple calls and then using the judge's phone to make a call. That's immediately, and then immediately the shooting took place. Now, in the testimony, Detective Stamper said the calls were to Stines' daughter. Now, Stamper said the phones had been sent to forensic teams for examination, and though his daughter's phone had not been examined, Stamper confirms Stines' daughter's phone number had been saved in the judge's phone and was called before the shooting. Detective Stamper said the two men went to lunch earlier in the day, and that's also corroborated by other people's testimony. And the detective said a witness said at one point Mullins, the judge, asked the sheriff if they needed to meet privately, though the context of that whole conversation was unclear to this witness. Now, Stamper said witnesses are still being interviewed throughout this process. Now, Detective Stamper also added that Stines was mostly calm when he was interviewed after being taken into custody, though he didn't offer a motive. Basically, all he said was, "Treat me fair," is what the detective said. When asked by a defense attorney, Mr. Jeremy Bartley, whether Stines said anything about protecting his family when he was taken into custody, Stamper said Stines allegedly made a comment that they were, quote, "trying to kidnap my wife and kid," end quote. Now, the attorney, Bartley, said more information would be provided, obviously, throughout the investigation, but he declined to speculate on a motive for the shooting outside of what has been discussed in court. Now, Stines announced Monday that he was retiring/resigning from his position as sheriff. Governor Andy Beshear, the governor of Kentucky, called for the sheriff to resign last week in a letter he sent to then sheriff while he was in the Leslie County Jail. Now, here's where things get a little interesting. Stines is also a defendant in a federal lawsuit alleging that he failed to properly train and supervise a deputy, later found guilty in state court of trading favorable treatment in the jail back in 2021 for women on home incarceration in exchange for sexual favors. And guess where the favors were being done? Allegedly, in Judge Mullins' private chambers. Now, attorneys claim that there were no cameras in Mullins' chambers at that particular time. Now, remember, Stines is not a personal defendant. He is named in his official capacity as the sheriff. So what we also know is that Sheriff Stines was deposed in that lawsuit just 3 days before the shooting last month. And during Tuesday's hearings, Stines' attorneys asked the detective on the stand about that case. But the detective said he was unsure about any of the details in that lawsuit. And the attorneys for the plaintiff in that case have said they were surprised by the shooting and are uncertain whether it was related to any depositions, let alone the sheriff's deposition just 3 days before. Now, the judge overseeing the case moved the case forward so it can go to the grand jury. The court found probable cause, and no particular court date has, in fact, yet been set. Now, this is where it gets a little interesting. I've received lots of information from people that purport they're local. There's been information out there was the judge doing something nefarious? We don't know. It's speculation and rumor at this point. We don't like to do that, but it's something that has been out there and actually been in some mainstream media sources, so to speak. There's allegations. We're not saying anybody did anything wrong, presumption of innocence. We're not trying to disparage anybody's name. There's allegations that maybe something was done inappropriately by the judge. Then there's also the potential speculation that maybe Sheriff Stines was not exactly a good guy, and the judge was trying to help Sheriff Stines' wife and daughter get out of a difficult situation. We just don't know. So we're just going to have to wait and see as more information becomes available. There's a lot of rumors going around out there right now, but you have to be careful as to what you say. But those are rumors. Now, going back to CrimeTalkSearch.com, all right? Just happened to, prior to the show, run a quick background report on Judge Mullins. Just happened to run one on Shawn Mickey Stines. Let me just tell you, ladies and gentlemen, these two men are probably the most boring individuals in the country. I don't think I've ever seen a report so boring. None of these people even had a speeding ticket. Nothing. We think there was obviously a Facebook page. We went to the sheriff's website there in Letcher County. It's down. The Letcher County Facebook page. Judge Mullins. These people are boring. They're not even buying cars. I think the most recent thing that the sheriff owned was a 2020 Kia. That was it. I don't know if these people have any possible energy or bone in their body. There's usually something that shows up in a background check that would indicate something, what was going on in their particular life. But that was it. The judge has owned a couple of properties in his lifetime. And it looks like he may own a couple of Ford Tauruses and a Ford Explorer. That's it, ladies and gentlemen. Unbelievable. You can't, but I guess is a good thing. Boring is good, but you just never know what you're going to find on those background checks. But the sheriff and the judge, apparently good friends. I don't know. Interesting story. It keeps me up at night trying to think of the motive. I want the motive. Like I said, was sheriff a good guy and it's a time to kill kind of situation? Or was sheriff a bad guy? Judge was helping out. Apparently the judge liked the ladies. I don't know. We'll have to wait and see. Was he trying to take away his family? Who knows? Who knows? It's going to be a good, interesting trial to watch. Hopefully we get there soon. Heck, we only had 3 weeks from the time of the crime to the preliminary hearing, so let's do this thing. Next, Sarah Boone. She wanted to be ready for her close-up. That's right. The woman accused of suffocating her boyfriend inside a locked suitcase raised some eyebrows when she requested professional hair and makeup for her upcoming murder trial. Now, the judge was initially going to allow Ms. Boone to have makeup applied by her legal team once she was already in the courtroom. That's what I've seen. I once had an associate apply cover-up makeup to a client that had done some various tattooing on his head while in custody. That's normally what the judges have allowed. However, the motion was denied when the sheriff down there in Orange County, Florida, explained that she had security concerns about the cosmetics, which are considered contraband in jail. So Boone was in court yesterday for a pretrial proceeding ahead of jury selection, which is scheduled to start Monday. We'll bring it to you live, assuming this thing actually goes. And as you may recall, Sarah Boone is charged with second-degree murder in connection with the 2020 suffocation death of her boyfriend, Jorge Torres, at their Winter Park, Florida apartment. Now, Ms. Boone claims that Torres was killed during an alcohol-fueled game of hide-and-seek, while investigators claim that videos from her photos showed that she was trapped inside a suitcase while he begged to be let out. Now, Ms. Boone can supposedly be heard laughing on the video as Torres calls out her name and says, "I can't breathe." And then Ms. Boone is reportedly on the video saying, "Yeah, that's what you do when you choke me." Boone is said can be heard saying on one of the videos. Now, during the hearing on Wednesday, Ms. Boone's new defense attorney, number 9, argued to have 2 hours of interview footage between his client, Ms. Boone, and the sheriff's office thrown out. In the interview shortly after her arrest, Boone repeatedly told investigators that Torres' death was an accident, which is also the legal argument put forth by Ms. Boone's first 8 attorneys. But the 9th attorney, James Owen, said a few weeks ago that he plans to pursue a battered partner defense, which does not line up with her comments in the interview. So therefore, you got to make the comments go away. So you file a motion to suppress. And in this particular case, the attorneys had Ms. Boone actually take the stand herself during that hearing as a way to have the lawyers get into evidence as to whether the footage should be admitted at trial. Ms. Boone had to testify, and she testified that she was very confused, she was hazy, and said during the interview that she was in shock, practically traumatized by the entire situation. Now, the Orange County detective in the video can be heard reading Ms. Boone her Miranda rights off of a card, which is not uncommon. But the attorney for Ms. Boone focused in on the fact that he did not include an extra line, having these rights in mind, do you wish to talk to us now? The question is not part of the official Miranda rights advisement, but was part of the script required by the sheriff's office policy, which is a policy, should be followed, not a law. Anyway, during Wednesday's hearing, the detective said that the question was not on the Miranda card that the sheriff's office provided to her. And she said, quote, "I've had that card since I started being a detective in sex crimes," end quote. Now, the attorney also argued that Ms. Boone did not realize that she was going to the sheriff's office to be interrogated and that she was basically lured to the sheriff's office for questioning under false pretense. Well, the detective supposedly called Boone to say that the detectives were going to be done with the search of her phone and asked her to come by to the sheriff's office to pick it up. And then on the stand on Wednesday, Boone claimed that she believed the only reason she was going to the office was to get her property and that she did not anticipate being questioned. The defense argued that this was tantamount to coercion. The prosecution, however, countered that it did not matter why Boone thought she was going to the sheriff's office. Kind of tend to agree. And she didn't have to go. She could have sent a representative, and she could have left at any time, but otherwise then she would be under arrest. Now, wouldn't she? Anyway, the prosecutors also pointed out to the court that she ultimately was read her Miranda rights, even though the detective left out that extra question. The judge agreed with this state analysis, but chose to wait one day before issuing a decision whether the interview could be included at trial. I anticipate that it will, in fact, come in. It's nice that people always seem to add something to it, but that doesn't necessarily make it the law. The Miranda advisement is very clear what needs to be included and what doesn't. I think it's coming in, which will go completely against Ms. Boone's defense. I can't wait for this trial. I want to watch every minute of it. We'll bring it to you live. I think it's going to be a complete circus, ladies and gentlemen. That's the word I was thinking of, not something else. A complete circus. All right, next on the docket. Now, here at CrimeTalk, we are free speech advocates, right? We should call this free speech YouTube right here. But we all know it's not. YouTube, well, let's face it, they censor people. They do. They censor people. We got censored for the longest time because people didn't like the words that we would say, like murder and sexual assault. And it finally took people to realize we were talking about stuff that was talked about on the evening news. But some people didn't like it, and it made their feelings not feel good. And so we would get banned and censored. It was unbelievable, the battle that we went through. Anyway, remember, you don't have a right to have your feelings not hurt. All right, ladies and gentlemen, we live in America. You want to go where no one's going to say anything offensive to you? I don't know where you're going to go, but here in America is not the place you need to be if that is how you want to live your life. But the question now here is, who is the dumbest person in California? Is it Gavin Newsom? Is it the California legislature? Or maybe is it the attorneys advising the legislature and the governor? Because I'm telling you, this is first-year law school type of stuff that people learn when you study constitutional law. So what am I talking about, right? Well, a federal judge has put an injunction over a 2-week-old California law that effectively bans election deep fakes. Now, the law was called AB 2839, and it allowed any person to sue for damages over AI deepfakes if the perpetrator's post resembles a political candidate within 120 days of an election and up to 60 days after. Yes, parody, ladies and gentlemen. You can't engage in parody sarcasm in California. That's literally what the legislature and Gavin Newsom, unbelievable that they would actually think that this would withstand constitutional muster. But fortunately, a federal judge with a lifetime appointment, a guy by the name of John Menendez, said artificial intelligence and deep fakes pose significant risk, but said the law is unconstitutional as it violates the First Amendment. The court found that AB 2839 is also unconstitutional under California's free speech provision. Now remember, ladies and gentlemen, the legislature has a duty to follow the law, right? The governor has an obligation to follow the law, right? They pass the law, but it should be constitutional. Why would they pass a law that they know is not going to withstand constitutional muster other than it makes them feel so good about themselves? Look what they're doing. They're doing something. And Gavin Newsom, everybody knows he wants to be president and he's trying to help people, right? But he passes this law because people were making fun of him. So how did we get here? This court decision comes from a case involving Christopher Coles, known as Mr. Reagan on X, which created a controversial AI-altered campaign video mocking United States Vice President Kamala Harris in July that was later shared by X executive, including well, that's right, Elon Musk. Elon Musk, I remember seeing this posted. It's like, send me to jail. Sue me. I dare you. Anyway, a lawyer representing Coles filed a lawsuit against the California Attorney General, Rob Bonta, and the Secretary of State, Shirley Weber, to block the new California law a day after the California governor signed it into law on September 17th. The law allows California judges to order distributors of AI deepfakes to take them down or potentially face monetary penalties. Menendez said that Coles is likely to succeed on his state constitutional claim and granted the motion for a preliminary injunction on October 2nd. Now, most of AB 2839 acts as a hammer instead of a scalpel, serving as a blunt tool that hinders humorous expression and unconstitutionally stifles the free and unfettered exchange of ideas, which is so vital to the American democratic debate, the judge said. The judge went on and said that he agreed that with Cole's lawyers that AI deepfakes of Harris was merely satire that should be protected by the First Amendment. While a well-founded fear of digitally manipulated media landscape may be justified, this fear does not give legislators unbridled license to bulldoze over the long-standing tradition of critique, parody, and satire protected by the First Amendment. AB 2839 is one of several new AI-related laws that has hit Newsom's desk in recent months. Now, Newsom recently vetoed the Safe and Secure Innovation for Frontier Artificial Intelligence Model Act on September 30th, which proposes mandatory safety testing of AI models. Newsom said that while well-intentioned, SB 1047 could place unnecessary restrictions on emerging AI companies in California. Protecting any speech involving public issues, involving politics, government, history, economics, law, science, religion, philosophy, and arts, but noted that the First Amendment doesn't protect all free speech, including extortion, threats, and defamation. So, what the California legislature and the governor, and thank goodness this federal judge gets it, but the United States Constitution, the First Amendment, protects any speech involving public issues, things involving politics, government, history, economics, law, science, religion, philosophy, and arts. And you can say nearly just about anything under the First Amendment, and the government cannot come after you for that. You can be sued civilly if you make extortion. You can also be charged criminally for extortion and making threats, and you can be sued civilly for defamation. But having somebody's feelings hurt doesn't involve government action. It can't, ladies and gentlemen. And the government can't ask a third-party company to do what they can't do themselves. Like, let's say, for example, if it got so crazy, and let's say somebody in the government didn't like what somebody was saying on the internet, and they said to the company, please take this down. We don't like it. It's mean to us. Well, that's the actual definition of fascism, ladies and gentlemen, where the private actors, the companies, do what they're told by the government. They're doing what the government can't do themselves. That is fascism, ladies and gentlemen, and it's scary that anybody would want to do that. So let's see how far the First Amendment really goes. There's an old adage out there that you can't shout fire in a crowded theater. Well, that's hogwash. Technically, you can, okay? It is protected under free speech law. Like I said, true threats, right? You can't do that. You can't extort people. But yes, you could say that, and they could not charge you with a crime. All right? So where did this come from? Well, that little saying is a favorite reference of censorship apologists, and it needs to go away. It's repeatedly and inappropriately used to justify free speech limitations. It is simply wrong that shouting fire in a crowded theater is unprotected speech. Now, where did this error come from? It goes back to the 1919 case of Schenck v. United States. The case concerned whether distributing anti-draft pamphlets could lead to a conviction under the Espionage Act at the time, and had nothing to do with fires or theaters. In his opinion, Justice Oliver Wendell Holmes wrote that the most stringent protection of free speech would not protect a man falsely shouting fire in a theater and causing a panic. However, this idea was introduced as an analogy to illustrate that the First Amendment is not absolute. It is what lawyers call dictum or dicta, a justice's ancillary comment that doesn't directly involve the facts of the case and has no binding authority on anyone. That's why they call it dicta. The phrase, though, an often repeated axiom in debates about the First Amendment, is simply not the law of the land now, nor has it ever been, something made all the more apparent when Schrenk v. United States was overturned in 1969 by Brandenburg versus Ohio. All right, so ladies and gentlemen, so as free speech advocates, let's get realistic. Get over yourself if you think you don't have a right to be offended. You know what your remedy is? Don't watch it. But guess what? You may watch something and you may be offended and you may realize, oh my gosh, they may be right, right? I thought that I went to college and had the classical liberal arts education, right? As a political science major, you were supposed to be exposed to all things. We read all the political philosophers throughout the day, okay? But you have to be exposed to those ideas and say, oh, I kind of like a little bit of this one. I like a little bit of that one. Yeah, this guy's right. This guy's not. But if the professor said you can't read any of this stuff, you can't make up your mind, I've decided for you, that's scary. The point is you need to question authority, you need to question premises, and see if it is in fact correct. Don't be some mind-numb robot and do what everybody says, okay? And when the government tries to make free speech illegal, you should all be very, very afraid. The government should be the one most often criticized, and no one should shut them down for criticizing the government. Next, Alec Murdaugh gets denied. That's right, a federal appellate court has dismissed Alec Murdaugh's appeal of his 40-year prison sentence for stealing millions of dollars in personal injury and wrongful death settlements that were ultimately diverted away from his clients. The Fourth Circuit Court of Appeals said that Mr. Murdaugh knowingly and voluntarily gave up his right to challenge his punishment when he accepted a plea deal, except in extraordinary circumstances. The court said his case did not present such a circumstance. Now, Murdaugh's attorneys had argued that the lengthy federal sentence violated his rights against cruel and unusual punishment because it was more than what was recommended under the sentencing guidelines. But the judge who sentenced Murdaugh explained in his sentencing decision as he handed it down back in April that the punishment was harsher because Murdaugh stole from needy and vulnerable people. And the victim included the sons of Murdaugh's late housekeeper, Gloria Satterfield, who died after a reported fall at his home. And during the funeral, Murdaugh promised to take care of the boys by suing his own insurance company, which he did. But then he stole the nearly all of the $4 million settlement, and the sons were left penniless after their mother died. In all, prosecutors believe that once the high-profile attorney from the powerful legal family swindled more than $12 million over a decade from former clients, colleagues, and even his own brother. So Murdaugh faced many of the victims of his financial crimes, and he pled guilty last year in state court. And the plea deal meant that the victims, spanning several counties, were spared lengthy trials in exchange for a 27-year state-run sentence, which was to run concurrent with his federal sentence. And Murdaugh's financial schemes were detailed as part of his criminal trial in 2023, and prosecutors pointed to them as motive, painting Murdaugh as a desperate man with a secret life that was about to be exposed when the murder of his wife and son came out on June 7th of 2021. Now, Murdaugh was found guilty and given 2 consecutive life sentences in state prison. He's appealing those convictions, claiming the trial judge erred in allowing financial crimes to be the evidence in the trial that made him look so bad. Or was it just the fact that he's on audio right about the time that his wife and son are killed that made him look so bad? I think the judge should have kept it out, but hey, that's just me. I think it just tainted the proceedings. Maybe a little bit, but not to the extent that it was allowed to come in. It probably did, in fact, prejudice the jury. But on to the federal sentence here. Listen, when you plead guilty in federal court, and these are quite common, I say quite common, I would say within the last 3 to 4 years in every federal plea, I've got one sitting on my desk right now, you sign an appellate waiver. And it basically says, and if you want to plea deal with the government, you got to agree to it. and it's an appellate waiver that says you're not going to appeal your decision unless the judge imposes an illegal sentence, which is greater than the maximum sentence, which is not going to happen. Or usually you try to work it in that if there's a certain guideline range and the judge goes above that, but Murdaugh's own attorneys didn't put that particular language into the plea agreement, so therefore the judge did nothing wrong. And therefore, appellate waiver, appeal dismissed. Ladies and gentlemen, there's an old adage that two people can keep a secret as long as one person is dead. Let me give you an example of that, right? So charging documents filed in the arrest of Jennifer Gledhill share some details about what led to the Utah woman being arrested for the alleged murder of her husband, Matthew Johnson. So a confidential informant informed officers that Gledhill confessed to the crime, saying that she shot her husband as he slept, and that's according to the arrest affidavit. Now, evidence found by detectives include a large blood stain in the carpet beneath the bed, obscured by a newly purchased mattress above on the blood-stained frame, and signs of significant cleanup, including recently bleached walls. Now, Johnson was reported missing on September 23rd from his Utah National Guard workplace. And then on September 28th, 2024, the Cottonwood Heights Police Department was in contact with a confidential informant who was reporting that they had spoken with Jennifer on the evening of September 22nd, 2024, at which time Jennifer Gledhill openly admitted to killing Johnson by shooting him in the head while he was sleeping. Now, Johnson was shot while on the mattress inside the mattress bedroom of their home in the Cottonwood Heights. Jennifer also told the confidential informant that she had removed the body of Johnson and had relocated his remains to a shallow grave at an undisclosed location. Jennifer Gledhill went on to tell the confidential informant that she had been removing items from the home and destroying them to cover up the crime. Now, several search warrants have been obtained and executed on various electronic devices, which apparently have led investigators to believe that the remains of Johnson's are in the same undisclosed location as described by the confidential informant. Once again, search warrants were obtained for the residence, and it was discovered where there were large blood-stained spots in the master bedroom carpet underneath the bed. Blood was also found in the bed frame slats, which support the information police were told. Evidence also support that significant cleanup had taken place after the crime scene had occurred, including bleaching the walls and cleaning the carpets. Now, the mattress was new, and phone records show that a new mattress was ordered on September 24th, 2024, and arrived just 2 days later. Now, since September 21, Matthew has had no contact with anyone, including his children. Now, Matthew's phone would go to voicemail, apparently, and Matthew never returned to work and never let any evidence that he would lead investigators to believe that he was still alive. Based upon this behavior and evidence collected through the investigation, it is believed that Matthew Johnson is deceased, the detectives are stating. Anyway, Gledhill was arrested Wednesday for investigation of murder in the first degree, obstruction of justice, felony conduct in the second degree, and if the case goes to trial, this will be determined obviously by a jury. The prosecutor requested no bail be issued because Jennifer has already tampered with evidence, according to the prosecutors, and there is still significant evidence that needs to be collected, and it is the prosecutor's belief that if she is released, she will attempt to further tamper, remove, or destroy critical evidence pertaining to this investigation. Not to mention, they also think she's a flight risk. Now, Ms. Gledhill was booked into the Salt Lake County jail system and has been held without bail. Just goes to show you, ladies and gentlemen, only one person can keep a secret. She must have really trusted that person who turned out to be like, I want nothing to do with this. Get me out of here. And next, hey, if you're going to kill your husband, turn off the dash camera. That's right, dash cam footage caught a mother ambushing and injecting her State Department researcher ex-husband with a deadly poison during a heated custody battle. Amanda Hovanek was seen waiting while her mother, Anita Green, for her ex-husband, Timothy Hovanek, to arrive with their daughter at her Ohio home on April 24th of 2022. That's when federal prosecutors say that she ambushed and injected him with an animal tranquilizer. Now, Timothy had just been given visitation of his 3 daughters just 2 days prior when a judge ruled that he be the residential parent of custody and legal custodian of 3 children for the summer beginning back in May of 2022 through August of 2022. But over the next 2 days, evidence shows that the victim and his daughter spent time together and swam at a Best Western pool, enjoying their time together before his untimely demise. Now, as the girls got out of the car on April 24th, Hovanec told her children, "I have a surprise for you inside." And just moments after the children and Green were inside the residence, Timothy could be heard saying, "What the heck are you doing? Did you just assault me? Get away from me. Get off me." They were citing the dash camera footage from the vehicle. Soon, both the husband and wife came into the camera's view, and Hovanec could be seen pulling on her husband's shirt as he tried to grab his cell phone. She wrestled with him and eventually knocked the phone out of his hand, according to prosecutors. She then pulled on his back to bring him back to the ground, holding him around the neck until his body went limp and became unresponsive lying in the driveway. Hovanec stood up, picked up her husband's cell phone, removed his smartwatch, and turned off his car engine, at which point the dash cam stopped recording. Now, court documents say that law enforcement officials later determined that the State Department researcher was injected with M99, also known as entrophine, a substance that is approximately 1,000 more times more potent than morphine. Now, Hovanec obtained the poison a few months prior when her South African boyfriend, Anthony Theodoro, sent a vial hidden in a package with jewelry and other items. Now, the suspects had earlier reached out to Theodoro to see if he could find someone who was willing to kill her husband, and the boyfriend checked in with an acquaintance to see if he knew any potential hitmen, where it always goes downhill from there. Anyway, it turned out that Theodore and his friend were able to identify 2 hitmen, but they either backed out or disapproved, prompting Hovanec and Theodore to resort to doing the poison themselves. She then injected her husband with the poison as he was unloading the children's car seat from the car in the driveway, according to the government's theory. And Hovanec then put a plastic bag over the head and body because she was concerned about fluids secreting from his body. 1 day later, Green drove Hovanec and Theodoro to dump Timothy's body in a pre-dug grave near a farmland near Hovanec's grandfather that he'd owned, and returned later to pick them up. Now, prior to killing Timothy, Amanda and her mother, Miss Green, that they were going to kill him, according to the probable cause affidavit. Now, after Amanda killed Timothy, she also informed her mother that it had been done. Now, Amanda and Theodoro loaded Timothy's bodies into the back of Amanda's Honda Pilot. Shortly thereafter, Green drove Amanda and Theodoro to where they buried the body. It also claims that Hovanec and Theodoro used shovels from Green's home to bury the body as well, and the missing person investigations began when Timothy failed to check out of a nearby Best Western hotel where all his belongings were inside. After local law enforcement learned that he worked for the State Department, the FBI was brought in to the investigation. Now, over the course of the investigation, police found Timothy's car abandoned in Dayton, Ohio, and they were able to recover the dash cam footage. At first, Hovanec claimed that her ex simply left after dropping off their daughters, but confessed when, there's that pesky video evidence. Anyway, Amanda admitting she ejected Timothy in the shoulder while they were standing next to the vehicle after he dropped the children off. Amanda was not able to name what she, in fact, injected Timothy with, but referred to it as poison or some sort of drug, and that he was going to die within minutes. She pled guilty to charges of conspiracy to import a controlled substance, importation of a controlled substance, conspiracy to possess with intent to distribute a controlled substance, and distribution of a controlled substance resulting in death. That carries a mandatory minimum 20 years. Anyway, apparently no matter how hard she tries to explain her actions, it just comes down to, she was being selfish, as she said at her sentencing hearing. And that selfishness got her 40 years in federal prison, followed by 10 years of supervised release. She was also ordered to pay more than $2.1 million in restitution. Green, the mom, was sentenced to 10 years in prison after pleading guilty to accessory of a crime. Guess what? The boyfriend gets sentenced Thursday, We'll let you know how that goes as well. All right, next on the docket, this day in legal history. On October 3rd, 1995, O.J. Simpson was acquitted of the murders of his ex-wife, Nicole Brown, and their friend, Ronald Goldman. The trial lasted more than 8 months and was one of the most publicized trials in American history. The verdict was highly controversial, with opinions divided somewhat along racial lines, and it sparked debate about the criminal justice system, race, and the media. And on this day in 1789, George Washington proclaimed the first national day of Thanksgiving. That's right, President George Washington proclaimed the first National Thanksgiving Day. And although not directly related to legal history, the act by Washington is important because it establishes federal proclamations and executive influence over national holidays, which intersect with U.S. laws and traditions. And on this day, on October 3rd, 1991, the Senate Judiciary Committee began hearing testimony from Anita Hill, who accused Supreme Court nominee Clarence Thomas of sexual harassment. Hill's testimony came after President George H.W. Bush had nominated Clarence Thomas, and it led to a nationally televised debate on workplace sexual harassment, race, and gender. Ultimately, Clarence Thomas was confirmed and is still on the bench. And finally today, our dumb criminal of the day. Let's see if we can find this guy. Take a look at these guys. The Houston Police Department are asking for help in finding 3 suspects involved in this aggravated robbery that occurred in April at a convenience store at the 200 block of North Loop West. The suspects are seen on camera approaching an employee at the register when the gunman demanded money. While there's also footage shows a second suspect putting on a mask while a third waited by the door outside of the store. Now all 3 fled in a dark colored truck. And investigators say the suspects are described as being between the ages of 11 and 22. And yes, the one guy didn't have his mask on. So if anybody knows who's the burglar without the mask, call the Houston Police Department. All right, ladies and gentlemen, that's all we have for you today. Thanks for watching. We'll see you next time on Crime Talk. Have a wonderful day. And remember, the Constitution matters.